With the limited number of judges and the ever increasing dockets of court cases, access to justice is a problem. The progress of the country, the exercise of nation building, the progress of the economy, the well being of the citizens, the reputation of the country, and whatnot, all depends on a highly efficient working judiciary, which I have no difficulty in saying is we don't have it, not as yet. In this country of 145 crores, we have about 30,000 judges at all levels. Now suppose you increase that number to 1 lakh, 3 times. Is it going to solve the problem? No. It's a question of the right numbers. You have to get the right man for the right job. You have to get the right man for the job of doing justice, meaning a man with the right mindset.
I would like to ask that we all know that you are from a political background. Your father was the Chief Minister of Assam, and thus you being the first Chief Justice whose father was a Chief Minister. So, sir, our question is what ignited your interest towards judiciary?
Many people call me a politician today because I'm a member of the Rajya Sabha. So, does it answer your question? No, I don't think it does because I'm not a politician. I'm a nominated member and I don't belong to any political party. It's a kind of a recognition that people thought that should be given to me, and that's how I am in the upper house of parliament. Yes, I come from a family of politicians, and the reason for not being in politics, in active politics, and instead choosing law as a profession is very simple. I had seen politicians since I was a child, and I thought I should be something else. My father was a lawyer. He joined politics, and I share a secret with you. He regretted it. I wanted no regrets, and I have no regrets. That's the answer.
Thank you, sir.
Sir, I wanted to know what's the role of judiciary in economic transition of India from socialization to liberalization? And being you started your career in 1978 when it was initially started and to resigning at 2019.
You see, after independence and after the constitution came in force, India experimented, I would use the word experimented, with a socialist economy. The powers, the political powers thought the economy should be guided by state control or state regulation. Now, the judiciary supported it. You had the land reforms, the agrarian reforms, the Jamindari abolition, abolition of Article 31, the fundamental right to property, the First Amendment incorporating Article 31A of the Constitution, the ninth schedule. When you put laws in the ninth schedule, you can't challenge the laws on ground of violation of fundamental rights. And most of the land reform laws were put in the ninth schedule. So what was attempted was a socialist economy where the agrarian wealth was sought to be divested from the hands of a few and distributed to the larger number of citizens. And the Supreme Court supported it. But somewhere down the line, with the economic crisis of 1990, the ideas, the thinking, the mindset changed, the policies changed, and we went towards, liberalization, then came globalization, a free economy. And down the line, you had the Supreme Court again supporting the government, the economic policies of the government. You had a Balco case in 2002, I think, where the Supreme Court said the court should stay away from deciding policy matters, particularly pertaining to the economy. You had the bank nationalization case. And therefore, the judiciary had a very, very significant role in altering the course of the economy and society, the thinking, the progressive values. And today what you have is literally a free economy where you have private sector banking, private sector insurance, private sector power generation, private sector aviation industry, and even private sector, to some extent, defense industry. And the challenges brought before the judiciary have been largely negative, and the concern of the judiciary is not so much today with regard to policies. That is best left to the elected representatives of the people. The concern of the judiciary today is human rights, fundamental rights, the rule of law, a fair deal to the citizens. This is where the judiciary is chartering its new course. And if you ask me for my personal view, I think that is the way to do it.
I would like to ask that how does judiciary balance the interests of workers and the employers while adjudicating labor disputes in this era of industrialization?
Let me tell you a very personal experience. Last month, a garment manufacturer who is in the export business invited me to see his factory in Noida. He has got 17 manufacturing units employing about 4,000 people. He is manufacturing what Jasraj and his friends wear, the branded products, which is exported out of the country. So naturally, the quality is very good. And the buyers of this product regularly visits his premises in Noida. And the first thing that the buyers, the foreign buyers do is to interact with the workers, with the laborers, to find out what kind of working conditions they have, what kind of living conditions they have, how happy are they with their jobs, how well paid are they, how are the health requirements of the workers and the families met. These are the interactions that take place between the foreign institutional buyers and the manufacturers in India. Now, the judiciary, to my mind, has had a tremendous role in transforming and safeguarding the working conditions of the average workman in the manufacturing sector. Whether it is fair wages, health care, living conditions, there are orders by the Supreme Court, by the High Courts. There are laws, rules, regulations in force which are being enforced by the courts, monitored by the courts. And therefore, things definitely have not deteriorated, and we are noticing significant upliftment of the working conditions of the laborers and the workforce in this country. Take a simple act like the Factories Act. Take a simple act like the Industrial Disputes Act. These are avenues of providing working conditions conducive to a good economic development of the country. And this is where the courts step in, and the courts have been very vigilant and very strict in enforcement of these pro-labor legislations. And that is why perhaps we are seeing an economic turnaround in the country where the products manufactured by units in the country are reaching the international market.
How the judiciary plays a crucial role in ensuring that there is equal access to justice for all stakeholders in this era of economic transformations.
See, this is an area where I think there's a lot left to be done. Much is left to be done. Access to the judicial system or limited access to the judicial system is what we have today. People are not able to come to courts for various reasons that we needn't go to. But the endeavor of the judiciary has always been to welcome people to come to courts with their grievances. But considering the country's population, considering the number of forums available, considering the judges available, there are serious limitations. You'll be very surprised to know that India has one of the lowest judge population ratio. It is presently somewhere in the region of 21 judges, which means 21 courts for 1 million people. That's 10 lakhs. Way back in 1987, that was 40 years back, the Law Commission of India suggested that this ratio should go to 50 judges for 1 million. Today, after 40 years, we are still struggling at a figure of 21 judges per million. Now, with the limited number of judges and the ever-increasing dockets of court cases, access to justice is a problem. And I'll be very happy personally if the avenues for access to the courts go up, and they need to go up. We are experimenting, the judiciary is experimenting with the legal services authorities. There are different forums under the Legal Services Authorities Act. But the success has been somewhat a little disappointing. But then life is full of disappointments. But that doesn't deter us, that should not deter us. The struggle continues.
So there was a case where you charged a man with a fine because they revoked the case one day before the trial.
They revoked, they withdrew the case.
Yes, sir, withdrew the case.
They withdrew the case,
Yes,
and I fined somebody.
Yes.
I don't remember that, but if I have fined somebody, I did the right thing. I don't believe I have done anything wrong, consciously. Unintentionally, maybe yes, but consciously, no. And I would request all of you, the students here, to proceed in life with this firmness and with this belief that whatever you do is right. Because let me tell you, there are no absolute rights and wrongs. Right is what you think is right, wrong is what you think is wrong. Now, Jasraj, if I find somebody for withdrawing a case one day before, look, Do you think that the courts are for fun? He had come to court, he has wasted my time, I have read his papers, and then he is in a mood not to press his case. Why should he go away? Okay, fine, pay for it. It's a fundamental law of economics.
That was the point, that you read 800 pages of this
Yeah,
document and then
I spent my time, I spent my energy. That energy and time could have been given to some other litigant in this hard-pressed system. The man comes to court, makes me read the papers, and he goes away. How can he go away scot-free?
So we have seen that the process of judicial activism, which was only contained to only public interest litigation, has increased rapidly with the increasing number of suo motu cognizance and judiciary taking place in guiding the legislature in the making of the laws. Has the process of judiciary or the involvement of judiciary increased?
That's a very good question. And it's a very difficult question to answer, but I'll try and answer it this way. You know, don't confuse between judicial activism and judicial overreach. What is judicial activism? You don't have a lazy judge, you have an active judge who participates, does his homework, and every minute of the court's time, he is alert, conscious, and keeps the fundamentals of the judicial system in mind. To my mind, I would call the judge an activist judge. In today's nomenclature, he perhaps would not be. That's why I said don't confuse between judicial activism, an activist judge, and a judge who's overreaching. You see, overreaching is when you are trenching upon the powers of the executive or the legislature. That is not judicial activism, that is judicial overreach. What is wrong is judicial overreach. What is permissible and welcome is judicial activism. You don't want a sleeping judge in court. You want an active judge, a judge who's alive to his duties, a judge who's conscious and alert all the time, who has, what are the values of the judicial system? What are the values? Democracy, judiciary in the strongest pillar, judicial independence, fairness, protecting the rights of the citizens, upholding the rule of law. These are the judicial principles. And a judge is expected to be independent, to be impartial, to decide according to his conscience, keeping in mind the law. A judge who is expected to uphold the principle of rule of law. Now, if he does that, does he become an activist? Though, in doing it, he may pass orders against the establishment. No. But then, on the other side, you have some instances, though there are few, where the higher judiciary does and has trenched upon the powers of the executive and the legislature. That's the belief. You see, I am today, rightly or wrongly, in Parliament. Right? And I do meet people who come and tell me what she has asked me. Judicial overreach. Yes, there has been judicial lawmaking. Judges are making laws. Judges are compelling the legislature to make some laws in a particular way. Judiciary is issuing directions which really pertain to the executive. But these are stray incidents. Everything in this world, everything in life is not perfect. There are deviations. And the judiciary is a part of an evolving society. And while evolving, we do make mistakes. The idea is to correct your mistakes. We all make mistakes, but we must correct them.
We all know that justice delayed is justice denied. And we also know that you are one of the most prominent advocates advocating the fact of judicial efficiency and judicial efficacy. So could you please throw some light on how you, during your tenure, had participated in this context?
What is your name?
Kriti. Kriti Bansal.
Kriti. The answer lies in that instrument that you're holding with your left hand. That's your mobile. What do
Yes,
you
sir.
use it for?
So for searching information, for calling people.
Yeah,
Yes.
that's a smartphone. It's not an iPhone.
Yes, sir.
It's okay. What you're holding in your left hand is the future, the technology. What you're holding in your left hand is not a mobile, not a cell phone. It's a supercomputer.
Yes, sir.
Correct. And the supercomputers are growing. Your question is about judicial efficiency.
Yes, sir.
What does it got to do with the mobile? You know, the issue of judicial efficiency and effectiveness is very dear to my heart, and it should be dear to your hearts. The progress of the country, the exercise of nation building, the progress of the economy, the well-being of the citizens, the reputation of the country, and whatnot, all depends on a highly efficient working judiciary, which I have no difficulty in saying is we don't have it, not as yet. The struggle, the endeavor is to have one. And maybe a day will come when we reach. I have mentioned to you the judge population ratio. That is a partial solution. In this country of 145 crores, we have about 30,000 judges at all levels, from the Supreme Court down to the magistrate, about 30,000 people. Now suppose you increase that number to 1 lakh, 3 times. Is it going to solve the problem? No. It's not a question of numbers. It's a question of the right numbers. You have to get the right man for the right job. You have to get the right man for the job of doing justice, meaning a man with the right mindset. The judge's life is not a 9-to-5 office. It's a commitment. It's a lifelong commitment. Find out 10,000 people who are committed people, they will do the work of 90,000 people. So you need the right kind of person to be a judge. So the endeavor in selecting judges must be not in filling up the vacancies, but in selecting the right man for the job. This is one. Now, we have reached a stage where we are all technology driven. That's the future. You know, the government of India is spending a huge amount of money on transforming the face of the judiciary, in digitizing the system. What is digitization? Is it a solution to the problem? Digitization is when you are using computers and the computer does things in a better way. It types out things in a better way. And when I was a young lawyer in the 70s and 80s, you know, to change one line in a page or one word in a page, you have to manually type out the whole page. Right? Today, you don't have to do it. Right? That is digitization. But to my mind, digitization is not the end, is a step in the process. The solution lies in digitalization. Digitalization is the end. Digitization is a step. We have not reached, or we have not even attempted to, or we are not even on the threshold of this process of digitalization. And what is digitalization? You know, say 100 pages of a document, say evidence of what a witness says. Today you have to read, a judge, the human element has to read all those 100 pages. You can develop softwares, and softwares were in existence, which will give you a summary of those 100 pages in 10 minutes. So what you can do in 10 hours, you do in 10 minutes. You save your time. That is digitalization. That has not happened. Unless that happens, no matter how many judges you get, how many courtrooms you inaugurate, and whatnot, nothing is going to happen. And I am not concerned with the government functioning, with how bureaucrats work, but I'm certainly concerned with how judges work. And I think the solution to India's long pendency of cases is to embark upon and complete this process of digitalization. I'll give you an example. A large number of cases in courts pertain to a very simple issue: motor accidents claims. Motor accidents claims. And today, in India, we have reached a stage, though not formally, of no-fault liability. Regardless of who's at fault, the victim or the victim's family should get compensation. Right? This is the thinking. Now, if this is the thinking, then I think this case, every case can be solved in 2 minutes. I tell you how. What is the age of the deceased, assuming it's a death case? What is the age? How long he would have lived? What was he earning? How much he was giving to the family that he has left behind? These are the parameters. These are all known facts. Work it out. If he was earning, say, 50,000 rupees a month, and he was giving 40,000 to his family, and he would have earned this money for 20 more years, you just multiply it. You don't even have to use your mobile for that, your calculator there.
Yes.
And you get the figure. Give that compensation. This is something like digitalization. Unless you do that, you have 5 crore cases. The total number of pending cases in India today is 5 crores. It's gone up phenomenally during the COVID time. These 5 crore cases are going to haunt this country. And by haunting this country, I mean it is going to it is going to shake the confidence of the average citizen. It will not attract, it's going to be a disincentive for foreign investors to come and invest, and it will be an affront, a direct challenge to the principle of rule of law.
The concern for the environment has been growing from the past few years. So, how does the judiciary ensure that the country develops economically at a sustainable rate?
I'm glad you asked that question. A clean and healthy environment is directly, or I would put it this way, the right to a clean and healthy environment is an essential component of Article 21, the right to life. And I can say with great happiness that this is an area where the courts have been very, very conscious, very strict. Economic planning within the parameters of the environmental requirements. There have been a few court orders which have been a little, had some negative results. But, when it comes to mining, which is a major cause for disturbing the ecology or destroying the ecology, whether it is the Karnataka mining, the Orissa mining, the Goa mining, these are all iron ore minings. The courts have been very, very strict, more strict than necessary perhaps, as many may say, because the court had ordered the closure of so many mines, leading to unemployment, leading to shortfall of requirement of iron ore, affecting the economic progress. But then the courts, whether you think it, you think the courts overdid it or did it rightly, that's another matter. The point is the courts have been very, very strict and vigilant in so far as environmental issues are concerned. Take the coastal regulations. They are being very strictly enforced. Right? All the habitats close to the seas are old constructions. Right? So I think the balance between development and regulations pertaining to ecology and environment have been wonderfully worked out. There are certain principles. The polluter pays is one principle. Sustainable development. You use the natural resources, keeping enough for the next generation. Intergenerational equity. These are some principles that have been developed by the courts. Sustainable development, intergenerational equity, the polluter pays. The polluter pays is an absolute principle. So I think the courts have done very well so far as the environment is concerned, and I'm really happy with the judicial achievements on this front.
So, sir, my question to you is that judiciary solves disputes between the center and the state. So, how does the court ensure transparency and not show partiality towards either of the parties?
If you really follow the spirit of the Constitution, which you and me, you don't know about others, but you and me, we follow the spirit of the Constitution. I presume you do. There is no room for conflict. You know that under the 7th schedule to the Constitution, we have 3 lists: the union list, the state list, and a concurrent list. Union list is of subjects over which Parliament makes laws. State list, state assemblies, concurrent list, both are competent. Center, the Parliament has an overriding power. The executive power extends to the subjects in these lists. So it's not only legislative power, it's also executive power. Obviously, the lists are little, they overlap at times. But then you have a judicial formula, the pith and substance theory, etc., etc. So really you don't have much room for differences. Are the states not a part of the Indian Union? Are the states not a part of Bharat? Are the states not duty-bound to march ahead with the nation? Is the task of nation building not the responsibility of the states? Why should they be in loggerheads? Now, there have been some instances. This is because the party in power in the states may not be the party in power in the center. Differences, sir, are always healthy. They are necessary for the growth. They are necessary for our evolving society. What is this world and what is this life without differences? Are you staying in the hostel? No. If you were in the hostel, then you would have realized the differences. I stayed in a hostel for 8 years. Every day we had hundreds of differences, but we were good friends, right? Differences is a part of growing up, is a part of the evolution of an evolving society. So don't get too worked up about the differences. And on a lighter note, even the media has to survive. We all have to survive.
Firstly, it's an honor meeting you, sir. Sir, my question is, as we've seen recently in cases like Ayodhya, which are highly sensitive and have to be treated very carefully, how do you deal with situations like these? What is your approach?
You said you are from SRCC. Are there trespassers here? Are there people from Hindu college also here?
Crowd here. It's open for all DU students.
How is the relation between Hindu college and SRCC these days?
Sir, it's fine.
Okay. Look, a judge, though he is a product of society, he is a disciplined product of society. When a judge decides a case, be it the Ayodhya case, be it the Sabarimala case, be it the recent cases that the Supreme Court has decided, he is a judge. Personal opinions, personal views, outside pressures, outside opinions, newspapers, TVs don't influence him. That is what a judge is. Thank you.